Yes.
May I be permitted to listen for inclusion of listed motion?
Of which year?
25. 25.
No order was passed previously.
Which was initially filed and inadvertently filed before approved 9 days, my lord. It has been released, my lord.
February.
My lord, for correction for the
What correction?
80% CPF was unpaid was made, but no interest is not.
Yes.
CPF. Unpaid CPF was ordered. Unpaid CPF. But no interest, 6% not interest.
Interest.
Interest on CPF, 80%.
You have to file an application. Sorry. Yes.
Well, this is an application.
No correction. Sorry.
Yes. This is inclusion in the list.
Additional order you are paying for interest on CPA, for which you have to file an application for modification. Yes.
But this is an inclusion in the list, my lord, as per hearing. In 2016, matter is going on, my lord, on the earlier determined.
2016 hearing matter?
2016.
No, I am not including any hearing matter at present. Yes.
Never appeared before.
Yes.
2025.
No order was passed. Hand over the slip, February month list. Sub notice upon the slip.
Application for
Yes.
praying for recalling, my lord, the state did not file any opposition. Time expired in November 25. Matter was due to appear in December. Let this application appear, my lord.
Application for recalling. Under the heading application sub notice. Yes.
Now, may I lordship's kind leave to mention a matter, my lord. This is for inclusion, wherein, my lord, the promotion of the chief, additional chief engineer of WBSEDCL has been challenged, my lord. What has happened in respect of this challenge?
Writ petition of which year?
2023.
Hearing matter you have to wait. I am not in.
Just submit the urgency after that. It is up.
Yes.
Well, the entire promotional policy, an entire promotion from the ground level till the chief engineer has been stalled. If it is not taken
so
up,
you are waiting from 2020?
No, my lord. There are 4 writ petitions, my lord.
One is appearing. I am also
there is another writ petition which my learned friend has filed. If it is appearing in your lordship, there is one writ petition which has been heard, which is heard by Justice Kapoor, my lord, as an assigned matter. The entire WBSEDCL will collapse, if this is not taken up.
Let me consider.
It is already there in the list.
There are other benches. Yes.
Number 63 is.
We only tag this matter with item number 63.
Without hearing, I do not tag it. Sorry. Yes. Yes.
Happened, my lord. I have been joined in a railway services Madhupur. Thereafter, I was released therefrom and I was asked to join in the Shialda. In the Shialda has not accepted my joining and my salary has been stopped from the month.
You are working in Shialda railways. So approach the tribunal.
No, the tribunal is not. It is a pure case article violation of Article 21.
No. If you are an employee, if it is RPF, then it's otherwise. Otherwise, a railway employee needs to approach the tribunal. I have already passed order. Sorry. And you are hit by section 14 of the Tribunal Act of 1985. What you are submitting? If you are a railway employee, you are required to approach the tribunal.
Then my local make it to be mentioned so that I can.
Not to be mentioned, motion or hearing?
Motion stage.
Motion, etake supplementary list diye debe to kalke. Listed motion of 2025. Hand over the slip. Compassionate Department, wait, yes. Because there are other benches. There are other benches for hearing. You mentioned before those benches because after motion and now these tribunal matters are also coming. This is a difficulty. So if I am able to include hearing matters and take up hearing matters, then mention I will include all hearing matters. Not in a selective way. I will include hearing matters. When I will start including hearing matters, I will allow everybody's mentioning. That I understand, but hearing matter, since I am not including, try to appreciate my predicament also. Yes. And I think there are other benches. You can try your luck. Yes. Hearing matter, I have just, you have just seen. So please don't waste court's time. Sorry. Yes. Sorry. Yes. Hand over the sleeve.
Lordship, motion, inclusion symbol.
Yes.
My lord, I mentioned before upgradation, my lord, the petition is a senior citizen, my lord. My lord,
What is the urgency?
My lord, this is delay payment of retirement benefit, my lord.
When retired?
In 2020. And the
20.
matter filed in 2024, my
So
lord.
2020 matter, you have to wait. So you are waiting for more than 5 years. Yes.
This my lord, last week, my lord, I have mentioned on hearing matter for fixation. My lord has not been pleased to fix the matter. My lord, I have prayed for release. My lord has been pleased to direct me to serve notice upon the other side. My lord, I have served the next day. My lord, that I am
Is it appearing under the heading hearing?
hearing.
Hearing.
Item number 415, my lord, there was a division bench order that I have shown to your lordship yes, last week, my lord, that my interim order application has been rejected. That portion has not been touched by the division bench. So far as the early hearing is concerned, there is no direction upon my lord also. It was
Next Monday to be mentioned.
my lord.
Yes.
Your Lordship,
Application of which year?
Application 2025 original application.
Application for what?
Application for restoration.
When dismissed for default?
For the default 5 months back, it was determination was changed. It was
Hand over the sleeve. Yes.
your Lordship.
Yes.
Your lordship, I'm mentioning for inclusion, motion, your lordship, this is service matter on last petition. Your lordship,
Motion of which year?
for the year 2023.
How many matters?
One matter.
2023 motion. What was the last order passed?
Your lordship directed to add a party, the executive engineer, and also to file a report on affidavit by the aggregate quantity.
If there is a report on affidavit, then it's not a motion. দেখি দাও তো কি order pass করেছে। Month list of February motion. Yes.
Your Lordship, if I may have your leave to mention a matter.
Yes.
My lord, may I permitted to mention a matter for inclusion in the list? Motion, Lordship.
Motion of which year?
2025.
2025. Hand over the slip.
Your
Yes.
Lordship, if I may have your leave to mention a matter for inclusion in the list.
For what?
So it's
Hearing or motion?
Motion.
Motion. Of which year?
2025.
Hand over the slip. Yes.
May I permit to mention for upgradation matter? It is a very urgent matter, my lord. My lord, this matter.
What is the urgency?
My lord, it is a forceful retirement for the respondent authority, my lord. I am the bare earner, only one bare earner in my family, my lord. Forcefully retired to my job, my lord.
I couldn't follow your submission. Yes. What is the urgency?
My lord, it is a forcefully retirement by the respondent.
When retired?
My lord,
Forceful retirement when took place? Ascertain and then mention on next week.
Motion matter 2025. Petitioners.
Hand over the slip if it is motion.
Restoration application.
Yes, restoration. When dismissed for default?
Dismissal on December 23rd.
23.
25 December.
Hand over the slip. Yes. Hand over the slip.
My lord, may I-
Yes.
Your lordship leave to mention 22 assigned matters before your lordship.
Yes, those matters already it was mentioned. Wait for some time. Let me see. It is in my mind. Let me see. You mention after fortnight. You mention after fortnight, Mr. Singh.
My lord,
I'll fix up because it has to be fixed up.
my lord, may I be permitted to mention, my lord, in this matter, in the 2022 matters, there is one matter, my lord, needs to be heard separately because it's related to 90% recruitment process. 90%
When those
vacancy.
matters will be taken up, then I will consider. Not now. Sorry. Yes.
My lord, this is
Sorry,
the
sorry, sorry. Please call
recruitment
the
is
list.
going on, my lord.
Yes, yes. Please call the list.
Item number 1.
My lord, I'm praying for not today, my lord. My lord, I'm praying for not today, my lord, on the ground of Mr. Dheeraj Tiwari, my lord.
Yes.
Mr. Dheeraj. Learned DSG, my lord. I'm praying for not today, my lord.
Where is he?
Perhaps he's somewhere, my lord. He's not available today, my lord. He's not available today, my lord. I'm
Why?
not aware, my lord.
The last occasion also I have taken time.
No, we have got everything, my lord. Written instruction is there. Everything is there, my lord.
Then not today.
My
Not
lord.
today.
Much obliged, my lord. Much obliged, my lord.
Item number 2.
Item number 2, I am for the respondent, Lordship. Lordship, kindly take the affidavit, Lordship. Lordship, learned DSG, Mr. Trivedi leading this matter. He is not available because he is a personal difficulty.
Not
Kindly
today.
not today. And kept in record, Lordship.
On same ground, Mr. Trivedi's ground, previous matter I have adjourned. Let it appear in the list tomorrow. Let me see. Yes.
Sure. Kindly.
Next.
Yes, sir. Lordship, kindly record the.
No, tomorrow.
Item number 3.
Yes.
Appealing for the petitioner. Last occasion, Lordship was pleased to, my lord, direct the bank file a report, I think. Lordship may kindly seize your Lordship's last order. Lordship wanted to see the chart. It has been prepared in this prepared and filed in this affidavit. Now, my lord, Lordship comes to lecture P1 at page 7. The chart is there. Now, my lord, if your Lordship kindly compares
Just
that.
a minute. Last occasion you submitted a chart.
Lordship, on the last occasion, I have submitted a chart. Your Lordship was pleased to direct to chronological transfer orders, also required.
Last affidavit was 1st December 2020.
Yes, yes.
Now, my lord, 1st December.
It was by way of affidavit.
It was by way of affidavit, Your Lordship.
1st December 2025, filing date, affidavit. I'll be praying your Lordship's kind attention to come to page 5.
Yes, 1st of December, you show me the chronological transfers of the
Yes.
petitioners.
Lordship, kindly take trouble to
Page
the
5.
Page 5 is the, what I
Chart.
wanted to show is that they had miscalculated my tenure in Kolkata, which was there in the previous affidavit, which is not there in the chart.
When petitioner was initially appointed?
Let's say initially he was appointed in Kolkata, Your Lordship. Your Lordship, kindly take trouble to the
23rd of September transfer date. So when petitioner was appointed?
6th of January affidavit which I Lordship filed.
Yes, tell me that.
Yes,
Tell me
Lordship,
that.
kindly see the internal page, running page, Your Lordship, where I have annexed the document page 7.
I want to know from you when the petitioner was initially
Yes,
appointed.
initially,
Tell me
Your
the date.
Initially, the petitioner was appointed, Your Lordship, on 23rd of September 2013 in head office Kolkata, also Allahabad Bank. Now it's merged with Indian Bank.
So you have shown it in your chart, 23rd of September 2013.
That's the in page 7,
Join at
very first column.
Just a minute. Tenure 23rd of September 2013 to 7th of July 2014. Duration 9 months. Then 8th of July 2014, transferred to Bhopal. Tenure 8th of July 2014 to 22nd of September 2014, 1 month, 15 days. Then Kolkata again, 23rd of September 2014 to 23rd of July 2016, 1 year, 10 months. Thereafter, 1st of August 2016, what is SAM Delhi?
SAM Delhi. State Assets Management Delhi branch.
States Assets Management Delhi. 1st of August to 23rd of August 2017, 1 year. Then Zonal Office Delhi.
Zonal Office Delhi.
27th August 2017, then 28th of August, 28th of July 2017 to 28th of September 2020, 3 years, 2 months. Then Asansol, 29th of September 2020 to 31st of March 2023, 4 years. Then Chinchura, 5th October 2014 to 5th of August 2014. Then Ahmedabad, not yet joined. So from 2022 to 2025, he is in West Bengal, first in Asansol and thereafter in Chinchura. Now, in Chinchura, this was a request made by the petitioner that not to transfer him when he was about to transfer to Chennai. Where is the transfer request?
Lordship, the transfer request, Your Lordship, I have annexed.
This I wanted from you.
Yes. Lordship, page 8 and 9 of supplementary affidavit December 2025.
This affidavit?
Lordship, 1st of December. 1st of December.
Page 8 and 9.
Page 8 and 9. First, at the bottom of page 8, Your Lordship, on 22nd of July, on 12th of July 2024, from Subratto Biswas, Lordship, at the page 8 of the bottom.
Yes.
From Subratto Biswas, subject representation on medical grounds regarding transfer order number such and such.
Just a minute. Now come to this table at page 5 of the affidavit. Posting was in Asansol on 29th of September 2020 to 31st of March 2023. Thereafter, from 5th October 2024 to 5th August 2025, he was in Chinsura.
Yes.
Now, what he did during this period from 1st of April 2023 to 4th of October 2024, this gap.
Lordship, during first of
after Asansol, he worked up to 31st of March 2023. Period, tenure.
Yes.
31st of then 1st of April 2023 to 4th of October 2024, because he joined Chinsura on 5th October 2024.
Lordship. Yes.
23, 23, 24 during this period.
Lordship, he was in Asansol, Lordship, because his earlier transfer order was modified, cancelled. Thereafter, it was modified.
तीन 2023 থেকে অক্টোবর 2024 পর্যন্ত। তিনের সাথে এটা হচ্ছে না। এখানে দেরি কেন? মার্চ মাস আর এখানে অক্টোবর মাস দেখাচ্ছে না। ডেটেড 29/6/2023।
What is the order of the division bench?
Yes.
Dated 24th September 2025. Is it not part of record?
No.
Yes, it's not, I have handed over, my lord.
Just a minute. Then it is there. Just you have not annexed it in the writ petition.
No, it was writ petition. Thereafter, there was an intra-court appeal arising out of the interlocutory order passed in the writ petition, and thereafter again that is the
No, this order which I have recorded, whereby authority
29th
was directed to
September.
reconsider your transfer order.
29th September 2025 order.
Yes, this is
24th
24th September
24th
2025.
Yes, yes.
Pursuant to which an order was passed on 8 October
Yes,
2025.
yes, yes.
So where is the order dated 24th September 2025?
Yes, this is the order. Adjournments. Page.
Now, where is the order dated, order passed by the authority which is under,
Page
which is under
73.
challenge?
Page 73
that
of
is
the bank's affidavit.
31st, that is 8 October 2025.
Page 73. Of
Yes,
the-
page 73 of the report of the bank.
Yes, that is the order.
But your submission appears to be a wrong submission with regard to your transfer to Chennai. You made an application, and based on that
No.
application, it was allowed by the bank authority, and you were transferred in from Asansol to Chinsura instead of Chennai. Only common thing is CH.
No, my lord, there were two
Chinsura,
transfers.
not to Chennai, but Chinsura.
My contention
And
was
dear
that
Mr. Lahiri, I remember it distinctly that it was submission on instruction. Your client was in court that no request was made.
for the first one was transferred. It was a management transfer. They themselves, my lord, rectified it on that same day itself.
You are working in Asansol and Chinsura from 2020.
2023.
Yes, 29th of September 2020, and you are working from 29th of September 2020 till 5th of August 2025, and thereafter you are transferred to Ahmedabad and it is yet to be implemented.
My lord, 2023.
2020. Please come to page 5 of the report which is filed. Yes, you worked in Asansol from 29 September 2020 to 31st of March 2023.
Yes.
Thereafter, you were decided to be transferred to Chennai. Now you made a representation that my parents-in-law are ill.
Yes.
It was considered, and you were not transferred to Chennai, but it was transferred. You were transferred from Asansol to Chinsura, not to Chennai. And you worked there from 5th of October 2024 to 5th of August 2025. So if you are working in Chennai and in Asansol and Chinsura from 2020 to 2025, what remains?
In the meantime, the transfer policy has come. And in any case, from Chinchura, it is merely, my lord, how many months? This was 10 months.
Yes.
Well, kindly seize the policy and the order.
And it was recorded in the order which is order dated 8 October 2025 issued by the Chief General Manager. Just a minute. You will appreciate that the bank has considered your previous request on 2 occasions and cancelled, modified your transfer order. On first occasion, transfer order from Zonal Office Asansol to Zonal Office Chinsura was cancelled in 2023. And on second occasion in 2024, your transfer order from Zonal Office Asansol to Legal Department Corporate Office Chennai was modified to Zonal Office Chinsura based on your representation,
Now, there
which was denied.
There lies the confusion. It is written 2 occasions. It was on 1 occasion. First was they have said management transfer in this reply in this chart itself. It was not on 2 occasions. On 1 occasion, that was my that was what I am trying to substantiate. That was changed from Chennai to Chinchura. Now, my lord, kindly sees the division bench directed the bank to consider my representation in accordance with the policy. But in the first occasion, your lordship was pleased to observe that there was no reference to the policy and there is nothing as to why my transfer was not considered in accordance with the policy. May I just again draw your lordship's attention to the policy clauses and thereafter come to the order passed by them, my lord. Lordship may kindly allows me once.
Order of transfer was specifically placed before me. I remember it. Regarding policy, tell me how the transfer order is hit by the policy.
Yes. Kindly, my lord. We have annexed it in the writ petition. Kindly takes it up, page 30 onwards of the writ petition. On the previous occasion, I have drawn your lordship's kind attention to the directions of the Ministry of Finance, pursuant to which this policy has been framed. Now, may I just draw your lordship's kind attention to the policy itself. First is 1.7. Lordship is there at page 30, my lord. Page 30.
Yes.
Page 30.
You placed it just a minute. You placed the relevant first day. You place 1.3.
1.3.
Normal
3 years. So Chinchura it is 10 months. Thereafter,
that will not apply here, Mr. Lahiri, because your transfer has to be considered last transfer from 2020.
State.
Because it was a special consideration on your request.
Even
That's why you worked in Chinsura from 5th of October 2024 to 5th of August 2025. It was in consideration of your representation. But your last formal transfer, which was given effect to, was 29th of September 2020, which is more than 3 years.
Even if it is 2020,
Yes.
then it will be 9 years in the policy itself.
Now the normal tenure of an officer at a place of posting will be 3 years of active service.
Yes.
So that 3 years is over.
That 3 years.
Yes.
in my humble submission,
Any other
1.7.
provision? Then you relied upon 1.7.
Yes. Seniority
Just
list, which has not yet been, my lord, published.
Transfer exercise by 30 June 2020. Mid-term transfer shall be considered only in case of promotions and administrative expenses. Transfer exercise will be the seniority model. So include ends transfer policy. Plans and seniority list and other details in order to bring efficiency and transfer. Why this transfer was not effected prior to 30th of June?
Lordship, with due respect, subject to Lordship kind consideration, if your Lordship go by the language of 1.7 itself,
yes,
my learned senior is reading only one proportionate portion. He's not reading as a whole. Your Lordship, the 1.7, the bank shall endeavor to complete the transfer exercise by 30th June every year. Mid-term transfer shall be considered only in case of promotion and administrative exigencies.
Yes.
So let's say his transfer was done in lieu of administrative exigencies in Samlarch, Ahmedabad, where the bank's NPA is more than 900 crore, which is
where you have stated in your transfer order.
In transfer order, it has not been spelled out, but it is not necessary, your Lordship, aware, because I am an employee. I am the best judge to which employees to be placed where, and administrative exigency. I will be the best person.
Have you defined it or explained it in your order, which was passed in terms of the order of the Honorable Division Bench? 29th of October 2024. What was the administrative, or it was the transfer order was in administrative exigency?
Your Lordship, yes.
October 2025 order, have you stated it?
Your Lordship, I have to, yes. Well, in detailed order, it has been passed, Your Lordship, thereby dealing with all the allegations. Lordship, may.
Specialist office.
Your Lordship, page 74, para 3.
Page 74, right?
Para 3.
Yes, yes. Yes, Mr. Lahiri, any other policy which you are relying upon? Any part of the policy?
5.5, linguistic region, and the most important is 5.9,
5.9.
Yes, 5.5 is in linguistic. It will be endeavor to
You
accommodate.
are law officer, what linguistic barrier?
We have to go through the title deeds. The title deeds are all in local language, my lord, of the region. In Hindi region, it is Hindi. Bengali region, it is Bengali.
If you would have been clerk, question would have been different.
I have to go through the title deeds for, my lord, ascertaining the my lord,
Officers in the
title of the properties which are being kept as mortgage.
ensure that
5.9 is the
customer
most
service
important.
to the maximum possible subject to availability of vacancies.
The bank shall endeavor to publish.
Now you are
any
relying upon 5.9.
Yes.
Just-
This they will never do.
Just a minute. The bank shall endeavor to publish in the list of officers of each zone in state of bank on an annual basis, along with expected vacancies at different zones. The officers will be as perfect on first. Seniority shall be right considering the overall tenure of officer. Yes. Anything more?
There are several, my lord,
Yes, sure.
branches. May I just say, I have not. I'll be relying upon a judgment also.
Yes.
Both the, my lord, petitioners and another colleague had approached
Yes, yes.
here. He had approached Allahabad High Court. He was also a specialist officer, my lord.
Yes.
It has in respect of him, the transfer order has been cancelled, my lord. Give the judgment. That's good. On this point, linguistic and this other point.
Which paragraph?
Paragraph 14 onward.
Sir, may I have a copy of? Oops, thank you. Thank you.
The judgments, everything has been recorded previously, my lord. In this case, he was also a specialist officer. Same cadre, my lord. Oh, jo copy acha. Same transfer date, everything is same. On consideration of, may I place it? Paragraph 15. When this court examines the whole scenario of transfer of the petitioner as well as the transfer policy, it is apparent that the post of petitioner is
Just a minute.
transferable.
Further submissions. Here petitioner rendered more than 9 years service outside home.
I have also.
Not now. You are working 4 years here.
My lord,
Issue.
my lord, kindly cease.
Please.
First
Yes,
posting
yes.
that they have said.
Matter is heard at length
And
in
my
the
lord,
presence of the
in
learned
the transfer
advocates
policy, it is 9 days
representing the
inside
petition,
the state.
representing the petitioner and state respondents. Representing the petitioner and and Indian bank authorities. Stop.
And my lord, there has been a charge sheet
Next
in the
paragraph,
meantime, my lord.
matter relates to transfer. Where is the transfer order?
Let's say the transfer order, let's say I have attached.
See, annexed in the writ petition itself.
Supplementary affidavit.
Page 29 of the writ petition.
Yes.
My contention is that
Matter relates to transfer order
should not be used against
dated
me.
18 July 2025, whereby petitioner was transferred what is SAM you have just
States assets management.
transferred to state asset management.
State
Apostrophe
asset.
S.
Look,
States asset management to states asset management within bracket SAM close bracket large Ahmedabad comma company recovery cell as senior manager from Chinsura, West Bengal. Stop. Stop. Petitioner is presently working as legal officer in zonal office Chinsura, West Bengal. Stop. In the writ petition, next paragraph, in the writ petition, transfer order dated 18 July 2025 and transfer order dated 18 July 2025, you didn't have the opportunity to challenge the subsequent order which is passed because there's a direction by the Honorable Division Bench to place it before this court by way of a report.
Yes.
কি বলছেন? Transfer order dated 18 July 2025 is questioned. Stop. In addition thereto, this court is required to examine the order dated 8 October 20 examine order dated 8 October 2025 issued by Chief General Manager which was passed in terms of the order passed by the Honorable Division Bench dated 24th September 2025, passed on an intra-court appeal being MAT 1601 of 2025 within bracket Subroto Vishwas versus Union of India and others. Stop. Vide said order dated 8 October 2025. Chief General Manager affirmed the order of transfer dated 18 July 2025, thereby transferring the petitioner to amendable. Stop. Next paragraph. Aforesaid intra-court appeal was disposed of by the Honorable Division Bench. Video order dated 24th September 2025. Directing the competent authority of bank to decide the representation of the petitioner, to decide the representation of the appellant within a specified time. And the outcome of such exercise was directed to be communicated to the petitioner or communicated to the appellant, who is petitioner in the present writ petition. Stop. Bank authority was also directed to file a report before this court in order to bring on record decision which was required to be taken in terms of the order dated 24th September 2025, passed by the Honorable Division Bench. Stop. Next paragraph. In terms of the order dated 24th September 2025, on behalf of a bank authority, a report was affirmed in the form of a report was filed in the form of affidavit. A report was filed in the form of affidavit which was affirmed on 31st October 2025, enclosing the decision of the Chief General Manager dated 8 October 2025. Stop. Next paragraph. In view of the decision of in view of the observations as contained in the order dated 24th September 2025, passed by the Honorable Division Bench, it is open, passed by the Honorable Division Bench, it is found that all issues are kept open. Therefore, court finds no impediment in deciding the transfer of the petitioner, deciding the merit of transfer, deciding the issue relating to transfer of the petitioner in consideration of the order dated 8 October 2025 of the Chief General Manager. Next paragraph. Mr. Anindo Lahiri, learned senior advocate representing petitioner, has submitted that order of transfer dated 18 July 2025, read with subsequent order dated 8 October 2025 of the Chief General Manager are contrary to the transfer policy for officers up to scale 3, version 2.1 of Indian Bank, requiring setting aside of decision of transfer of the petitioner from Chinchura to Ahmedabad. So, reliance is placed on clause 1.3, comma, reliance is placed on clauses 1.3, comma, 1.7, 5.5,
5.1 also. 9 years in the same state. T29.
and 5.9 of the said policy. ওই ট্রান্সফার পলিসিটা যেখানে বললাম ডেসক্রাইব করলাম ওখানে হিয়ারিং আপনার রেফার টু সেট পলিসি করলাম, হ্যাঁ, of the said policy.
9 read with 10. Expected vacancies has to be published.
Stop. In addition, there two other clauses are also relied upon in order to substantiate case of the petitioner. Stop. Next paragraph. Stop. Reliance is also placed on a judgment of the a judgment of a learned single judge or a judgment of the honorable single bench of Allahabad High Court dated 19th December 2025 in WPANR in the writ petition being writ-A number 13255 of 2025 within bracket Shubham Bhargava versus Union of India through Ministry of Finance Department, comma, Financing Services, New Delhi, and others. Stop. Next paragraph, it is also submitted in reference to order dated 8 October 2025 of the Chief General Manager that petitioner never requested the bank authority for reconsideration of his transfer after decision was taken to transfer the petitioner from Asansol to Chennai. Same was not given effect to. And in consideration of such request made by the petitioner, he was posted at Zonal Office Chinchura on 5th October 2024. Stop. Next paragraph. Bank authority has resisted, has made now on behalf of bank authorities, submissions are made to resist the prayer of the petitioner relating to transfer, which centers around transfer order dated 18 July 2025 and subsequent decision taken by the Chief General Manager on 8 October 2025. Stop. In terms of the order dated 20th November 2025, a supplementary affidavit was affirmed on behalf of the bank authority on 1st December 2025 including email letter of the petitioner dated 8 December 2020, dated 22nd August 2024, requesting the bank authority not to give effect to the order of transfer by which petitioner was decided to be transferred to Chennai. In 2024. Stop. Next paragraph. It is also specifically submitted on behalf of the bank authority by drawing attention of this court to relevant part of the order dated 8 October 2025 that petitioner, being a specialist officer, was decided to be transferred to Ahmedabad. as per business requirement and administrative exigencies. Next paragraph. Next paragraph. The chart showing chronological transfers of the petitioner from 2013 is disclosed under paragraph 2 within bracket small d of the report affirmed on 1st December 2025. Stop. From the said chart, it appears that petitioner was transferred and posted at Asansol on 29 September 2020. And thereafter, nearly after a span of 5 years, on 18 July 2025, petitioner was decided to be transferred to Ahmedabad. Stop. In the midst, petitioner was decided to be transferred to Chennai, which was not given effect to on the request of the petitioner, as email letter was issued, as an email letter was made by the petitioner on 22nd August 2024, requesting the bank authority not to give effect to the transfer order, to the said transfer order for his posting at Chennai. Therefore, it emanates that petitioner is therefore it emanates that working first in Asansol and thereafter in Chenchura from 29 September 2020 till date of last transfer order dated 18 July 2025, which is more than 3 years. Therefore, it is not a transfer of the petitioner within the span of 3 years. As such, clause 1.3 of the said transfer policy is not infringed. Stop. Next paragraph. It is also contended on, or it was also contended on behalf of the petitioner in reference to clause 1.7 of said transfer policy, that bank should make endeavor to complete the transfer exercise by 30th June every year, semicolon, midterm transfer shall be considered only in cases of, by 30th June every year. 30th June every full stop. In the present case, petitioner was transferred on petitioner was decided to be transferred on 18 July 2025. That is post June of post 30th June of that particular year, within bracket 2025 close bracket, which is impermissible. However, clause 1.7 contemplates midterm transfer is permissible in case of promotions and administrative exigencies. Stop. In the order dated 8 October 2025, it is specifically spelled out that the petitioner is a specialist officer who needs to be deployed in areas of his domain, according to bank authority, such specialist officer is involved in supporting services of bank's core business, and as such, his transfer is being dealt with separately. Therefore, administrative exigency as it is provided under clause 1.7 of the said transfer policy is defined in the order dated in the said order dated 8 October 2025, requiring transfer of the petitioner being a specialist officer for supporting service of bank's core business. Comma. Therefore, as a special case, court does not find it necessary to interfere with the transfer order, as administrative exigency is involved. Next paragraph. Under clause 5.5 of the said transfer policy, bank is required to make an endeavor to accommodate officers in respective linguistic region, quote unquote, to ensure seamless customer service, subject to availability of vacancies, administrative requirements of the bank, etc. Therefore, there is no specific provision that petitioner is required to be transferred within the linguistic region considering the vernacular used by the petitioner, as it is explained in order dated 8 October 2025 that administrative exigency is one of the grounds for transferring the petitioner. Vide transfer order dated 18 July 2025. Next paragraph. Reliance is placed heavily on clause 5.9 of the said transfer policy. Whereunder it is provided that bank shall endeavor to publish seniority list of officers of each zone/FGMO/state online on an annual basis along with existing/expected vacancies at different zones, close FGMOs. Semicolon, the order of semicolon, dita kete dao. Order of movement of officers will be as per order of movement of the officers as per said seniority list. Stop. On reading of paragraph 5.9, on reading of clause 5.9, it appears that bank authority shall make an endeavor to publish seniority list. But if such seniority list is not published, it is not contemplated that there shall not be any transfer, especially when such transfer is required on administrative exigency. Stop. However, it is expected that bank authority shall take necessary steps for early publication of seniority list as contemplated under clause 5.9. Next paragraph.
10 also, 5.10, expected vacancies, because there are many vacancies in West Bengal. Kolkata itself.
It was specifically submitted on behalf of the petitioner as recorded in the order dated in paragraph 4 of the order dated 20 November 2025, that petitioner did not make request not to transfer him to legal department, corporate office, Chennai, but same appears to be incorrect submission made on behalf of the petitioner, perhaps due to wrong instruction given to the learned advocate. Stop. It is disclosed in the report on behalf of the bank authority, which was affirmed on 1st December 2025, that previously a request was made video online later dated 22nd August 2025, 22nd August 2024, sorry, 22nd August 2024, after decision was taken to transfer the petitioner to legal department, corporate office, Chennai, and exceeding such request, petitioner was not transferred to Chennai. Rather, petitioner was permitted to be posted at Chinsura with effect from 5th October 2024 and worked there till 5th August 2025, and thereafter transfer order dated 18 July 2025, petitioner was decided to be transferred to Ahmedabad. Stop. Therefore, it transpires that once a request of the petitioner was accepted and previous transfer order was not given effect. Next paragraph. Decision rendered in Shubham Bhargava Supra by Honorable Single Bench of Allahabad High Court dated 19 December 2025 does not come in aid of the petitioner, since on the fact situation that bank officer was in service for more than 9 years outside his home state, decision was taken therein. Decision was taken therein. Stop. Here situation is reverse, as petitioner is working from 20th September 2020 in home state, and once decision to transfer the petitioner to Chennai was postponed. Next paragraph. In view of aforesaid consideration,
Another, my lord.
court finds
Charge
no
sheet.
ground to interfere with the transfer order dated 18 July 2025 and subsequent decision of the general manager dated 8 October 2025. Stop. Hence, writ petition stands dismissed. Urging xerox.
My lord,
Of
kindly
language.
record, my lord, there is a charge sheet which
Huh?
has been issued. Kindly record there is a charge sheet which has been issued for my lord answer his absence, alleged absence. My lord, I am litigating before your lordship, and my lord, there was.
I have passed my orders. Sorry, Mr. Light. Enough is enough.
Of
My
language.
lord, no worship action in the meantime, my lord, kindly.
Item number 4.
Madam, appealing for the added respondent, Provident Fund Authority. Lordship, in terms of the Lordship direction, I have served the EPFO authority. And Lordship, I also filed and prepared an exceptions to the report.
You are for the EPFO?
My lord.
What is your instruction?
My lord, in consequence of the Honorable Supreme Court's order, my lord, dated, my lord, 25th April 18. My lord, the regional banks, regional rural banks, they are excluded from the purview of the EPF-MP Act. Thereafter, my lord, we have issued, our head office issued a circular, my lord, page 85 of the writ petition, my lord. Kindly see, my lord, page 85 of the writ petition. The subject is, my lord, exclusion of employees of regional rural banks from the purview of the EPF-MP Act. My lord, kindly see, my lord, second paragraph of the letter, my lord. My lord, provisions, may I read, my lord?
Exclusions.
Provisions for transfer of accumulation out of pension fund in respect of members existing, exiting from EPF 1995 are contained in para 39B thereof. My lord, the accumulation of the employees of RRBs may also be transferred to the respective pension funds as per the modalities prescribed in the indicated paragraph. So, my lord, accordingly, my lord, we have transferred the pension accumulation to the bank, my lord, transferred. But, my lord, next paragraph, my lord, however, the employees of the RRBs who became eligible for pensionary benefit under EPS 1995 prior to the date of exclusion from the EPF and MP Act will continue to receive such benefits from the EPFO. No transfer accumulation of such employees therefore will be required. So, my lord,
yes.
So before the date of the judgment, my lord, whoever has attained, my lord, kindly see, my lord, section 6A of our act, my lord, of the pension fund, my lord, pension scheme.
Just a minute, however. RRBs, regional rural banks.
Rural banks,
Regional. Yes. EPS is Employees Provident Fund Scheme.
Employees pension scheme.
A pension scheme.
Pension scheme.
So for pensioners, no transfer of accumulations of such employees therefore will be required.
Yes, madam. So whoever is, my lord, eligible for the
So
pension,
they are entitled to get pension directly from
EPF,
Provident Fund
because we have not transferred their accumulation, pension accumulation to the bank. My lord, kindly see, my lord, who becomes eligible, my lord, when they becomes eligible, my lord. Lord, para 6A of the scheme, my lord, EPS scheme.
Employees Pension Scheme 1990. Para 6A.
A, my lord.
So that is not conditional if petitioner, if these pensioners are getting pension from the bank.
My lord, firstly, my lord,
because under the scheme they are entitled.
Yes,
and the accumulation is not transferred to the bank.
No.
So therefore, irrespective of payment vis-a-vis non-payment of pension by the bank authorities, petitioners are entitled to get pension from under EPS.
As per the accumulation, my lord. Whatever accumulation we have, according to that we are ready to pay, we are paying them, my lord. We are disbursing the pension. Till December we have disbursed. Whoever, my lord, kindly see, my lord.
So what bank is doing? Bank is adjusting this amount from their pension.
Bank regularly deducting my pension, whatever I am getting from the EPF.
What is your stand? Whether is there any condition?
We have no direction, my lord, upon the bank. Yes. We have no direction, my lord. But kindly see para 6A. That para, my lord.
Do one thing. You file a short affidavit. I am fixing a date and matter will appear under the same heading. So it should be on record. Why you are deducting in the event?
My lord, kindly look into page 120 another petition.
My lord.
Forget about authorization. That authorization is in connection with payment of pension by the bank authority.
Only for age 58
It is under the scheme EPS Employees Pension Scheme. They are getting pension. Why
the
it is adjusted?
It is they are retired from the age of 60. Superannuation age in the bank is 60, but in the EPS scheme they are getting pension from the 58.
As mentioned on 6A, my lord.
58. That 2 years is deducted money from the that 2 years period, which is bank contribution only.
But how that is related to related to bank's domain? Because it is under the scheme. Under the scheme, Provident Fund organization is paying it. Under the scheme. So, suppose there is an annuity. There is an annuity pension, as in the case of port trust employees. It is an arrangement made with the LIC. Now, under that particular scheme, this pension is being disbursed. But subsequently, if the pension scheme of the bank is revised or modified as a result where petitioners are getting pension, or the employees of the bank, retired employees of the bank are getting pension, how that will be impacted?
Well, it is the bank contribution to the employees provident fund for 2 years period. As per the regulation 3 of the our pension scheme, that was adjusted only for the 2 years. Some are 30,000, some 50,000, some not regularly.
So you want to deduct it for a period of 2 years?
Yes, only 2 years.
Very well, you don't deduct at this stage. Let the matter be hard on affidavit.
Only Bongio Gramin Vikas Bank, my lord, it is already deducted 2018. But in PBGP, my lord, page Kindly look into their only read petition, my lord, page 121.
Okay, as on today, even the month of January, they have deducted also.
My lord, for the.
What is the saying?
They are not
here?
annexing, my
Even
lord. I am
today that they are
report-
No, they are deducting since there is no restraint order, they are deducting. Now, the thing is, these other banks have done this.
Bongio Gramin Vikas Bank 3, they are taking from the its area. They are already deducted it from area for the petition at 2, 3, and 4. But regarding the Paschim Banga Gramin Bank, they are 7,755 employees. They are saying that they will deduct it from their EMI scheme for this excess amount, which is from the age of 58 to age of 60, which is from the 2 years. Some are 30,000, some 40,000, some 45,000. They are
No,
different.
how you can deduct it if that pension is payable under the scheme?
Well, kindly look into page 121 one of their petition. May I read, my lord?
Regulation for this is not.
Do one thing, first you file an affidavit, short affidavit disclosing your stand, and serve the copy of the affidavit upon the learned advocate representing the petitioner. I am fixing a date. Issue.
Also, in the meantime, lots of let there
No,
be
in the
stay-
meantime, nothing. They are deducting it. In the meantime,
Page
nothing,
9,
let me consider.
39 also my lord, relevant, my lord. Kindly see, my lord. Page 39 of the writ petition.
Yes, you disclose it in your affidavit.
Lordship, only one thing, their authority under regulation 47. 47 is not applicable. Lordship, kindly see 122. Lordship, my senior friend is referring regulation 47 of their scheme.
No,
Section
he
47 absolutely
is
different
submitting
thing.
that this in order to attract the scheme,
Yes.
payment was made by the bank.
That is
Because at that point of time, there was no provision for releasing pension to the employees. Now, if the payment was made by the bank and subsequently there is modification of pension scheme as a result whereof employees are getting pension, in that event, why petitioners will not be, in that event, why bank authority will not be permitted to deduct? Especially when in view of the authorization made by the respective employees that permitting the bank authority to adjust the amount.
Lordship, there was no authority of the bank permitting the bank to deduct the amount. Now, Lordship, they are saying only regulation 47 permits us to deduct this amount. Kindly come regulation 47.
In terms of the today employees for Provident Fund organization, employees plural apostrophe, is represented by learned advocate who has made submissions. Stop. Next paragraph. Concerned authority of employees Provident Fund organization is directed to file a short affidavit disclosing their stand in the matter by 10 days,
2 weeks,
by fortnight from date. Stop. List the matter under the same heading for further consideration on February 9th, 2026. Let me see, matter requires consideration. That how far bank authority is responsible or is
Lordship, this is
for releasing pension under releasing pension under the pension scheme, which was prevalent.
Yes.
Now, subsequently, there is introduction of pension scheme, as a result whereof the bank employees are getting pension directly from bank. Now,
As
whether
well as from the
that
PFO.
obtainment of pension impacts the right of the petitioners to get pension under the EPS or not.
EPS,
Yes,
Lordship,
ma'am.
as per this
This category stated, my lord. In the notification, it is stated.
that who
My
are
lord, may I
getting
read my notification, my lord?
getting.
Disclose
Ma'am,
it, disclose it.
ma'am.
Let it be on record. Let me see.
I will clarify the age 58 to 60. That could be also necessary.
Yes.
Even EPS, my lord, they are get pension from the age of 50. But in regulation, my lord, they are 60. From 58 to 60, that 2 years.
Let them disclose it.
Right.
Next.
Item number 5.
My lordship.
I'm for this for number 8 and 9. There was a direction upon us to file a report in the form of affidavit.
Not received copy.
Yes, report.
Lordship, just right now he hand over me the copy.
Now देखिए report तो देखिए. Yes,
Just right now he hand over me copy. I want to file a exception.
exception you want to file.
Right now. To go
So let him let her file an exception.
My lord, from the end of ECL authority, you want to file a report.
Not necessary at this stage. Because court wanted to know that when this claim
My
was
lord, on the
forwarded.
last
When this
occasion,
claim was forwarded.
last occasion,
Claim was forwarded way back on in the year 2008. And the account number was given is allotted.
Where is the claim? Forwarding of claim.
That is in Annexure A. Annexure A. That claim was returned. That is 10 and 2014.
So what you have disclosed in the report? Have you made payment?
I have made payment to one Chinath Patru because the account number given in the writ petition is of Chinath Patru, not of Chinath Gouda. Subsequently, when we have informed them, the concerned colliery, that payment has already been made against this claim, they have forwarded a further later dated. It is annexed.
Page.
It is in the last 16. It is 16. It's 16. In page 16, they have forwarded a letter to us stating that his account number should be in last line 2/290/B/360.
Letter dated 23rd of letter dated 25th April 2019.
23rd April.
Just a minute. Refund in respect of.
Page 16, sir. This is later dated 27.
Just a minute.
page 30 and page 16. We have received a letter from ECL that is on page 13, and in reply, we have sent them another letter that is in page 16.
Lordship, kindly consider the page 16.
But this is a payment made to one Trinath Patro and the CMPF number is different. 2/2/219B361. But PF contribution in respect of 2/219B280 has already been refunded to Trinath Patro.
Yes.
Who superannuated from so-and-so colliery, Pandaveshwar area, so on. But in respect of above member, has been confirmed as CMPF number is 219B361.
Yes.
So how
Now
it
the
can
thing
be
is
construed
they
as
have-
payment to Trinath Gowda?
They have mentioned in their writ petition this account number 280. This account number has been mentioned in the
Please
writ petition.
try
and
to appreciate
in
the
identity card also.
try
this
to
number was
appreciate the difficulty of the petitioner.
I understand.
Petitioner what? Petitioner is Trinath Gowda. His CMPF number is 292/219B361. So why
But his
petitioner will not be
identity
paid?
card is not saying so.
If a wrong information was provided by ECL, for that you take steps against the ECL.
Yes, yes,
But
yes, yes.
but why petitioner will suffer for the wrong information provided by ECL?
We have served a notice.
Petitioner
of
needs to
ECL.
be very well. You take whatever steps you want.
Yes.
But petitioner needs to be paid.
Certainly he'll be paid. We are
So
here to
pay.
make payment. 23rd April 2019, we have communicated a letter to the area personnel manager, Kunusturia area, that is the concerned colliery, to provide the detail of contribution against this account number to the Provident Fund Authority. But they have not yet replied to that letter. That letter dated 23rd April 2019. After this correspondence, no further correspondence have.
Where is that correspondence?
That is in page 16.
Yes, page 16.
And another thing is this, and another interesting, the details of this account number.
Area manager Kunsturi. So how it was responded to? The letter dated 23rd April 2019 of the Assistant Commissioner, Coal Mines Provident Fund.
My lord, I have received only today.
Yes.
I have
No.
received this information only today, right now from them. I have to get instruction on it. But last occasion.
On 23rd of April 2019, it was intimated by the Assistant Commissioner that payment was made to one Trinath Patro, not to Trinath Gowda having CMPF number 2/219B361. Then it was requested by the Assistant Commissioner under circumstances it is requested to kindly furnish contribution details in respect of Trinath Gowda petitioner. Now when you have furnished contribution details, simple thing.
My lord, we have deducted contribution from the account of the petitioner whose number 280, this is correct number.
280, yes.
280 is correct number, but that is not in respect of Trinath Gowda. It is in respect of Trinath Patro.
No, my lord, according to our record, the petitioner's number is 280, not 361. And we have
And name is
negotiated
Trinath Gowda.
with the Provident Fund Authority up to till his retirement. We have deducted. My lord, is highlighted portion. We have deducted the contribution from the petitioner, whose father's name is Judhishthir. And throughout, and in this account, money has been deposited.
Which account?
280.
280.
That is the account of the petitioner.
Yes.
But petitioner's name is not telling. Assistant Commissioner said that it was in connection with
As per the
account of one Trinath Patro, not Trinath Gowda.
my lord,
Trinath Gowda's account is 219 B361.
my lord, page number 4 of the writ petition, kindly see para number 3, the statement made by the petitioner. Para number 3.
Lordship, kindly come to page 20.
Just a minute.
Para 3.
Permanent interest.
Your petitioner states that your petitioner was a permanent employee of Eastern Coalfield Limited and was posted at Bansla OCP as wagon leader.
But you have stated that your CMPF number is 280.
Yes.
Lordship, as per the ID card, the CMPF number is showing 280.
So then it has been paid.
No, Lordship, no. The thing is that kindly come to, that's why I'm telling you, Lordship, kindly come to page.
Then Mr. Go Thakurata, your affidavit will be considered as affidavit in opposition of the Provident Fund organization. Let there be decided on exchange of affidavits. Sorry, issue. In terms of the previous order dated 11 December 2025, a report in the form of affidavit is filed on behalf of Regional Commissioner, Region 2 CMPF, Office Asansol, being response number 8, affirmed on 13 January 2026. কি বললাম সেমিস্টার বলো তো 8 and 9. Now on behalf of respondent numbers 8 and 9, 8 and 9 and which was affirmed on so and so date and same is taken on record. Stop. This report shall be treated as affidavit in opposition on behalf of respondent number 8 and respondent numbers 8 and 9. Stop. ECL shall also be at leave to file affidavit in opposition to this writ petition by 3 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph. Next, petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits. Next. এটা ওর সঙ্গে রেখে দাও।
Item number 6.
I am appearing for the petitioner.
6, I am appearing for
his accommodation. My advocate and record has not been able to come, my lord, due to, my lord, a personal difficulty, a medical reason, my lord, pertaining to his son, 2 years old son. My lord.
Well, in that event, next Monday.
Next month.
Not this week.
My lord, one prayer. Ms. Tejani Ghoshal is appearing for UGC and she has gone to Chennai for personal reason. My lord, kindly take this matter on 20th because 19th she will return.
Record an order at the time of call. Accommodation is paid for on behalf of you are for the petitioner. Accommodation is paid. File at the time of call. Accommodation is paid for on behalf of petitioner due to personal ground of the advocate on record. Stop. However, Union of India.
I am appearing for Damodar Valley Corporation.
However, DVC, however, Damodar Valley Corporation and UGC are represented by learned advocates. You are for the who is for the Union of India?
He is with me.
So, however, respondents are represented by learned advocates. Next paragraph. On behalf of UGC, also accommodation is paid for due to accommodation is paid for since learned advocate is unwell. Stop. List the matter under the same heading for further consideration on 28 January 2026. Next.
না তো এখন বলছি, এইটা এইরকম।
Next.
Item number 7.
I am for the petition. The last customer. Yeah, please.
Yes, what is the present position?
But he has joined the transfer post. Yes.
So what remains?
No, the case, the matter is regarding APR.
I see order dated, my lord, 1st December 2025. My lord, regarding the performance number in page 89.
Relating to?
Performance given by the authorities.
Just a minute. Just a minute. Yes.
But there are materials to justify the reduction of the marks, my lord, because there are several complaints received against the petitioner, not only from his colleagues or seniors, even from clients. He was,
Then why two other members given higher marks?
yes, because my lord, these reporting officers and the reviewing officers, my lord, they don't consider the overall thing. The CMD, if he has worked under several projects. The reporting officers are the immediate seniors. They don't have the knowledge of what is happening in what he has done in the other projects. Whereas the CMD has to take an overall view, and there are letters of complaints my lord, addressed to the CMD level also. Regarding the clients, Indian Oil is our client, my lord, the client of the Vision Roof. They have written to us, my lord, regarding kindly transfer this person from this particular project because he is misbehaving even with the clients. These are on record. I can, if lordship.
No, but there is a board or a committee constituted comprising of 3 members. Now it is alleged in the writ petition that chairman and managing director, that is CMD, awarded 49, but other 2 members awarded higher marks.
Well, it is not
79.64.
That is traveling the score, page 89.
Yes.
Chairman and managing director awarded 49, whereas others awarded 79, 79, 79, 68.
It is not a,
5 members, total 5 members.
yes.
Annual performance assessment report.
My lord, first the others, it's,
So you are submitting that CMD on certain considerations awarded.
yes, yes, of course. Or even the comment is there right below the,
It is subjective satisfaction. Mr. Chaudhary.
This person is not working under.
Where is the scope of interim order at this stage?
No, there is no interim order. Let him file the affidavit because my lord,
I shall be no record, my lord, the documents, what has been considered.
for that reason not getting the post.
Now, and I am recording that the petitioner has already been transferred to Meghalaya.
Yes, sir.
There is no.
Lawyer advocates representing the petitioner and respondent number 3 to 6 have jointly submitted that petitioner has joined the post at Meghalaya as deputy manager on transfer. Stop. Next one. However, in the writ petition, annual performance assessment report for the year 2024-2025, for the year 2024-2025 is challenged as chairman and managing director awarded 49 marks, whereas other 4 members awarded higher marks, much higher marks. Stop. Next paragraph. On behalf of respondent numbers 3 to 6, it is submitted that on certain considerations, chairman and managing director awarded low marks, and submission is and prayer is made to allow the respondents to file affidavit in order to disclose the materials based on which marks were awarded to the petitioner. Stop. Next paragraph. Let affidavit in opposition to this writ petition be filed by 3 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits. Next.
Item number 8.
My lord, I'm for the petitioner. I'm led by Mr. Firdo Shamim. He's at the Supreme Court, so I'm praying for not today.
Have you deposited the court fee? Well, file it on the next date. Issue. At the time of call, accommodation is paid for on behalf of the petitioners. However, state respondents are represented by learned advocate. Stop. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 4th February 2026. Next.
Item number 10.
My lord, I'm from the petitioner. Affidavit of service. My lord, affidavit of service. No.
Correction code. কি
আপনি না তুমি বলো তুমি বলো হ্যাঁ জানি না আমি কি করে জানবো আমার ছিলাম
Have you served notice?
Yes, my lord.
Where is every service you have 5? Yes.
Every service I have.
Yes. What is the matter?
My lord, the petitioner joined as Anganwadi worker, helper in the year 2007, 1/1/2007, after proper method, means after application, interview.
Where joined?
Joined in Modhamgram, Barakpur ICDS project on 1st October 2007 after getting selection through written test and Viva VC. After that, she is working over there for last 18 years. Now, my lord, what happened? Government, they have Government of West Bengal, Department of Women and Child Welfare, they have issued one memorandum. My lord, kindly come to page number 23, Annexure P2. Over there, it is written that in para 2 at page 24, method of distribution of vacancies posts of additional Anganwadi centers in existing ICDS projects which are more than 5 years old from the date of operational.
Page 23, paragraph
24, my lord. 23 is the starting of the memorandum, and at page 24, para 2.
Yes.
My lord, first there were 86 centers. When the petitioner joins, there were 86 Anganwadi centers. Subsequently, another 82 Anganwadi centers were opened in the same project. Now, my lord, over there.
What you are praying for? You are working there as you are submitting.
Yes, my lord.
What you are praying for?
Praying for promotion, my lord. Promotion to Anganwadi worker, AWW. Because I am
any process is initiated for appointment of Anganwadi worker?
No, my lord. Regular promotion they are giving one by one. 3 times they have given promotion, and my client.
Show me that there is a provision for regular promotion automatic.
Yes, my lord. That is, my lord. I am coming to this memorandum. Memorandum dated 25th January 2006.
Yes. Which part of this memorandum?
Para 2 in page 24.
Just a minute. Helpers. So you want to be promoted to the post of Anganwadi workers?
My lord.
Now working as helper.
Helper.
Now, why petitioners is not being considered for appointment as Anganwadi worker? Because 5 years is over. And there are two conditions that Anganwadi petitioner has to be who have at least 5 years working experience as Anganwadi helper in respect of government run ICDS projects will be filled up on the basis of recommendations by the respective selection committee. Now, petitioner wants to be appointed as Anganwadi helper in from
helper to worker.
Yes,
Promotion.
from helper to worker, right?
Now, my lord, in the writ petition, my lord, it has been stated that on earlier occasions when that, my lord, the promotional, my lord, the process was taken up with regard to this, my lord, on the basis of the circular or memorandum. First of all, my lord, that circular of 2006, my lord, to some extent, my lord, it has been modified on 20th December 2013. Now, 2006 is to be read with 2013. Now, may I just hand it over? Rusty, kindly, my lord, may I hand?
What are the modifications made?
That, my lord, at page 38.
Allow him to make submission.
Yes.
My lord, almost same.
Does it
Almost
take
same.
away the right of the petitioner?
No. Right remains. Right remains. Right remains. Now,
what are the changes made? What are the
change as it appears only in respect of, just a minute, my lord, the qualification change, if you also kindly come to, so for 2006 it was qualification was minimum qualification class 8 pass.
Where it is provided in 2006.
My lord, kindly come to 2006 notification. If you lordship kindly come to, my lord, the D, capital A under that small d.
Capital A.
Yes.
Yes, small d.
Yes. At page number, it is annexed here too.
Yes, page number 23.
Yes, and my lord, the qualification mentioned
But under A, there is no such provision. A, B, A, D. You have
D. A small d. First A1.
Relating to educational qualification, nothing is provided under D.
My lord, kindly, for the time being, if you lordship kindly have a look. My lord, the document annexed to my, there, my lord, the instruction or report, whatever it may be, if you lordship kindly have a look. Just now I, my lord, handed over. My lord, just my, now, the first annexure of this document is, my lord, that the memorandum of 25th January 2006. Have you got it, my lord? That I,
It is 20th December 2013
my lord, kindly
and
come.
25th January 2006 is enclosed at page 23 of the writ petition.
Yes, yes.
Yes.
Now, at page, if I come to page 29,
Page 29, yes.
yes. Now, kindly, my lord, kindly come to, my lord, the small d, and the caption is qualification for recruitment by promotion from Anganwadi helpers. At the bottom, to some extent. Have you also got it, my lord?
Yes.
Now, in the matter of promotion, minimum qualification is class 8 passed.
Class 8 pass, right?
Class 8 passed. Now, my lord, for the time being, my lord, let us not consider the
The
subsequent
petitioner is
amendment.
class 8 pass candidate.
Yes, my lord.
Then,
Now,
After that, she increased her qualification.
yes.
no, I just want to bring to your lordship kind notice that after that 2013, there is another memorandum.
Yes.
That is, my lord, the
28th December 2013,
yes,
which you have annexed.
Yes, my lord.
Where you have annexed?
Page 38.
Page
38.
38.
yes.
Yes, page 38, 20th December 2013, Mr. Sen.
That, my lord, the minimum qualification standard that has been changed.
Yes, show me.
Class 10.
Where it is provided minimum qualification for marks aforesaid exams. Clause F. Yes, class 10. Under
Yes.
the guideline 1.
Guideline 1.
Capital 1.
Yes.
10.
Yes, yes, yes. Class 10 pass.
Then,
now, my lord,
That is, my lord, regarding 2014, one exam held. That time, I have not got. I appeared at the examinations and viva voce, but I didn't get the promotion. In 2019, they have given for 7 candidates promotion without any notification.
now, my lord, kindly come to. I think, my lord, his, my lord, contention is that he is otherwise eligible, but, my lord, he has been deprived. Now, in the writ petition, my lord, it has been stated that since, my lord, 2019, my lord, she is trying, and one after another, my lord, the notification or advertisement inviting application was published. But always his cases, my lord, the ignored or he has been deprived, including that 2023. And after that, 2024 also published for that, my lord, the giving chance for promotion.
But no exam is held.
Now, he has not applied also. Now, if you lordship kindly have a look, my lord, I think, my lord, I have handed up, lordship, kindly go through, my lord, this. Well, it appears that on earlier occasion, either he applied, but, my lord, he failed to, my lord, obtain the minimum, my lord, the marks, because he has to obtain the minimum marks, not minimum marks as I say that this is the cutoff. No, but, my lord, his marks, whatever he obtained the marks, always, my lord, below the, my lord, the person who has been promoted. Because the number of, my lord, the post are, my lord, that according to the, my lord, the circular or memo, the percentage of, because direct and by way of promotion, a certain percentage by way of promotion from the helper to worker, and another certain percentage by way of direct recruitment. Now, so far this post, my lord, each and every year or alternate year, whenever, my lord, vacancy occurred, my lord, the publication made, my lord, either he applied or he did not apply. When he applied, then it appears from the records that, my lord, he, my lord, failed to secure.
He did not come within the zone of consideration.
Zone of condition. Now, my lord, kindly come to, lordship, kindly come to, my lord, my instruction is that so far 20th December 2023, that
2013. 28 December
another exam
2013.
held.
No, so far the another exam held. The last exam, see, my lord,
28 December 2023.
yes, Lordship, kindly.
Yes.
The petitioner was not selected because she could not
You are
come
reading
into
from the instruction.
Yes, C.
C.
C. The petitioner was not selected because she could not come into the zone of consideration, a result of insufficient marks scored by her. Now, if your lordship so desire,
She was not selected because she could not come.
and for the
Yes, yes. Now, what is your submission?
now, my lord, my submission is that if your lordship so desire, then my lord, the authority can be, my lord, asked to place the minimum marks the person who has been selected and the marks he obtained for the purpose of, my lord, that is, my lord, that to see that yes, there is transparency or he has not been deprived. Because
That is
here
in connection with which examination?
only that is, my lord, the examination, the last she participated, that is, my lord, for the year 2023.
5th October 2023.
Yes.
Notice inviting applications.
Yes. And so far the next, my lord, the D, it appears from D. Notice inviting application for promotion to the post of Anganwadi worker from willing helper was issued on 30th August 2024, the next year, after following all regulation. However, the petitioner did not apply for promotion in response to the aforementioned notice. So,
When not applied and appeared. My lord,
in 30th August 2024 notification you applied.
it is not from my personal knowledge, whatever instruction
30th
I said.
2024 notification you applied.
Yes, my lord, but no exam held. No exam held. That I have mentioned in the writ petition, my lord. My lord, my humble submission to your lordship to come.
Will you file a
Para
report?
number 11, my
Mr. Sen,
my lord.
Let the ICDS project officer file a report disclosing that who was the last candidate,
my lord,
who was favored with promotion in connection with
2023 exam.
Yes. Notice dated 5th October 2023. And whether the petitioner applied based on notice dated 30th August 2024 or in terms of the notice dated 30th August 2024. And let a report be filed on the next day.
No, may I tell, lordship, kindly, so far the prayers are in the writ petition. It appears that, my lord, 2024 notification or, my lord, the advertisement published, but that is not, my lord, the subject matter. The prayer is with regard to that 5th October 2023 only. The scope is, my lord, if you lordship kindly have a look. The prayer is granting promotion on the basis of
the basis of the result of promotional examination
5th October 2023.
In which petitioner is
and nothing more.
My
Nothing
lord,
more.
I have one thing, my lord, kindly allow me. Para 11 of the writ petition at page 7, I have distinctly mentioned that those 11 candidates, when my client was 8 pass, my senior learned friend told that she could not get marks and whatever may be. There I have specifically mentioned that out of these 11 promoted AWWs, 2 number candidates passed Madhyamik 10th class examination, 3 numbers candidates passed class 8, 2 numbers are class 4 pass. Educational qualification of 3 numbers candidates are unknown, and 1 candidate is illiterate and could not even sign but could put her thumb impression. She got promotion.
That you have stated in paragraph 19.
11, my lord, at
11.
page 7, 8. That I have
Paragraph
specifically
11.
mentioned.
The paragraph 11 with regard to the examination conducted in 2014.
Yes, my
that
lord.
is also not the subject matter here.
Entire writ petition, my lord, I have
That is in connection with 2014 examinations. Read the entire paragraph 11. Paragraph
No, my lord.
2014 examination is not under consideration in view of the prayer in the writ petition.
Yes, my lord. My lord, I have described the entire history. Entire history.
Yes, sure.
And my lord, 2020. My
Petitioner,
lord, kindly come to page 57.
affidavit of service filed on behalf of the petitioner is taken on record. Stop. Next paragraph. Petitioner prays for promotion from Anganwadi helper to Anganwadi worker, as petitioner is working as Anganwadi helper for a long period of time, having requisite educational qualifications. Stop. Petitioner has made a prayer to promote her to promote her as Anganwadi worker based on examination held as per notification dated 5th October 2023. Stop. It is submitted that petitioner participated in the examination which was conducted pursuant to said notification dated 5th October 2023. Stop. Next paragraph, Mr. Sen, Mr. Amol Sen, Amol Kumar Sen, learned additional advocate general, submits on instruction that though petitioner participated in the selection process, which was conducted pursuant to notification dated 5th October 2023, but she did not come within the zone of consideration. Next paragraph. District Project Officer, ICDS Project Barashat, being respondent number 3, is directed to file a report in the form of affidavit disclosing the marks and disclosing as to why petitioner was not considered for promotion in connection with the the selection process which was conducted in terms of notification dated 5th October 2023, and also respondent number 3 shall disclose the marks awarded to the petitioner and the marks awarded to the last candidate under the category of the petitioner who was promoted to the post of or who was promoted as Anganwadi worker
on the basis of that
in
examination.
connection with said notification dated 5th October 2023.
My lord, in this regard,
Next paragraph, let such report be filed by fortnight from date. Stop. A copy of the report shall be supplied to the learned advocate representing the petitioner. Stop. List the matter under the same heading for further consideration on 9th February 2026. Documents filed today on behalf of the respondent, state respondent, are taken on record.
My
He is coming.
না না ওকে আরো বলবে তাহলে আমি পরে বলবো।
1 minute, I am coming. Now, filing মনে হয়
এই আমার এখানে মেটেরিয়াল গুলো এখানে দাও।
Item number 9.
এখানে দাও মেটেরিয়াল। ওটা দাও। পুরো বইটা পুরো সেটটা একসঙ্গে দিয়ে দাও। দাও। Mr. Dotto has taken an interesting point, technical issue, Mr. Bhattacharya, that in terms of section 15, tribunal is constituted. What? Tribunal is constituted, 1985 Act, but tribunal is not functioning. Benches are not available. Now, if tribunal is not there, now if the order is passed by the single bench, then this is not an order to be constituted an order under clause 15 of latest patent. So therefore, no appeal is preferred. Now, to that extent, what is also passing through my mind is this, that as you have pointed out from the relevant part of L. Chandrakumar, that tribunal is functioning as supplemental to the High Court. And if tribunal is not there, then the old system revives for a period till tribunal is constituted.
That's the Supreme Court order also. So let him finish.
Yes, Mr.
Milord, as your lordship desired, Milord.
And not only this, there is another aspect, Mr. Dotto.
Yes.
I am confronted with two orders of the division bench. Now, one of the orders I was reading
From your order.
from my order, appeal was
Nothing decided.
Yes, but please see the order of Arnob Odhikari.
Yes, yes.
Do you have the copy of
Yes,
this
yes, I
order
have.
dated 19 December 2025? Come to the second page of this order. Paragraph 6. In our considered opinion, this order dated 15 December 2025 cannot sustain judicial scrutiny for the simple reason that as a rule of thumb, it cannot be said that the recruitment process cannot be called in question for any reason whatsoever. That is one aspect. Only after examining the grounds raised by the appellant showing illegality of the recruitment process, an opinion can be formed whether writ can be entertained or not. Secondly, if selection was pertaining to state government service, that is relevant. State government services, certainly its recruitment process can be called in question before the state administrative tribunal. Full stop. As per section 3Q, read with section 14 and section 19 of Administrative Tribunal Act 1985, the recruitment process can also be called in question before the tribunal. Full stop. If tribunal was not functional, it was obligatory on the part of this court to hear the matter, otherwise the party will be remediless. Yes, which court, whether division bench or single bench, that has not been explained there. Then come to paragraph 9, registry shall list the writ petition WPA before the appropriate regular bench in the next week. We have no doubt that learned single judge will hear and decide the matter in accordance with it.
That's the conclusion. Yes. Your lordships have decided that a judgment is an authority for what it decides and not what can logically arise therefore. Now, the interpretation of this order, first of all, this is not a judgment, be that as it may. From this, my lord, it cannot be logically concluded that in the absence of any argument on the point on which we are dilating, in the absence of argument on the points that we are discussing, advancing before this court, can it be said that all these points get decided in this judgment? With respect, possibly no. Now here, this is a case where the court was primarily, we are also concerned. The court was primarily concerned that don't make a litigant remediless because the institution is not functioning.
Yes.
We are also saying that.
I am also saying that access to justice is part of Article 21. So it cannot be denied. Now the question is, in the peculiar situation, because of a constitutional amendment, because of 323A, because of Section 28 of Administrative Tribunals Act, because of the latest patent getting scuttled, and because of L. Chandra Kumar, what is the remedy? Should it be before a single bench or before a division bench? Well, one of the arguments, quite rightly, made by Mr. Bhattacharjee that I lose a forum. Why, Mr. Bhattacharjee? The respondents also lose a forum. The question is, Milord, whether, Milord, through a judicial fiat, Milord, a right of appeal can be granted. Because look at it from the reverse point of view. According to me, subject to correction by your Lordship will deliver judgment on this, that it must come before a division bench. Why? Because L. Chandra Kumar has said this. We cannot presume that Supreme Court was oblivious of the procedure in various high courts like Calcutta High Court, that writs are entertained and heard initially by a single judge, and then there is an intra-court appeal before a division bench. But it cannot be presumed that the Supreme Court was not aware of these systems which are prevalent in various high courts. But still, Milord, Supreme Court chose to confer or restore the right of judicial review before a division bench. Now, if you look at it from a reverse point of view, if that a single judge is entitled, or I put it in another way, that a litigant is entitled to come before a single judge if the tribunal is not operational for some reason, then, Milord, through a judicial fiat, Milord, a right of appeal is being created. Right of appeal can only be created by way of a legislative action, not by way of a judicial action. That is my concern only, Milord. I don't mind, Milord, going.
Yes, you at the threshold you submitted that your effort is to assist this court, nothing else.
Because wherever, Milord, speaking today that I am for the respondent, if the petitioner loses a forum, the respondent also loses a forum.
Respondent is stronger party.
So this is what, Milord, is passing through my mind. But
and court is apprehensive of the fact that if ultimately Mr. Bhattacharjee's contention is allowed, in that event this court will be transformed into an tribunal.
Yes. Yes.
But that is not a point. That is not a ground at all.
But please have a look to this, Milord, 2-page note, Milord. I'll give a copy to Mr. Bhattacharjee also. I've just jotted down my points. But your Lordship may skip over, Milord, the first 2 paragraphs.
Yes.
Or the first paragraph. Please check the second paragraph. Part 14A was inserted in the Constitution by the 42nd Amendment in order to introduce the alternative institutional mechanism by setting up tribunals. Articles 323A 2D and 323B 3D, they empower exclusion of jurisdiction of courts. Then Parliament framed the Administrative Tribunals Act. Section 28 excludes the powers of this court to exercise jurisdiction over service matters. Complete exclusion. The analogy can be drawn from the next paragraph. Whereas the West Bengal State Legislature enacted the Tenancy Tribunal Act, Section 8 does not completely take away the jurisdiction of the High Court. Section 8 saves the jurisdiction of the High Court to entertain petitions by a division bench in relation to land reforms.
There I have a thing to one point which requires clarification. That in 1997, L. Chandra Kumar was decided.
Right.
Now, whether this notification for constitution of a tribunal was in 1997 and this act of WPLRTT is an act of 1997. Whether considering the issue decided in L. Chandra Kumar, perhaps that was taken into consideration in the act of 1997.
I have to check up the bill then. I have to check up the bill.
That might be the reason. It struck my mind.
Maybe.
Because there is a sharp contrast, as you have indicated, that in terms of Article 323 2D vis-a-vis Article 323B 3D. Now they are in Section 28, power of the authority of the Division Bench of High Court was not saved. But in WPLRTT Section 8, it was saved. So if it is saved, is it after post L. Chandra Kumar judgment?
No, I'll check up. But Milord, Section 8 of
এই WPLRTT টা একটু আনাও তো কালকে আনালে একটু
আমি তো ভুলে গেলাম আজকে ভুলে গেলাম
Section 8
but Milord, only thing is Milord,
দেখো তো এখানে খোঁজো মনে হয় আনিয়েছিলে হ্যাঁ এই তো Now this was
L. Chandra Kumar was
and this is 12 December 1997.
Yes. The difference is here, Milord, under Section 8, the original jurisdiction has been preserved, not as a court of second instance. Going by the expression of the tribunal of L. Chandra Kumar,
except where court in case of High Court, except where court exercises jurisdiction under Article 226 and 227.
the constitutional. I've read it. Therefore, this is the original jurisdiction.
That was in view of L. Chandra Kumar.
That I'll check out.
Because it is it is post L. Chandra Kumar notification. Notification was issued on 12 December 1997. And L. Chandra Kumar, as they are submitting,
L. Chandra Kumar was there.
Right to that.
No doubt about that. No doubt about it.
That's why it is specifically to conform to the view expressed in L. Chandra Kumar. It is provided under Section 8, Mr. Dotto, that where the court exercises writ jurisdiction under Article 226 and 227 of the Constitution by division bench. Yes, that is the purport of L. Chandra Kumar.
But please consider whether this will create any difference. Possibly not. Possibly not. In the way, Milord, I am arguing, if I am right in my understanding, this possibly because it is a post L. Chandra Kumar legislation reserving the High Court's jurisdiction and by the legislature. Here, in the other one, it is under Article 141 a jurisdiction is created. And here it is by way of legislation a jurisdiction has been retained. Again, we have to go back to clause 44 of the latest created.
Subject to the...
Yes. Subject to state legislations. Then, Milord, coming back to my note, 6th paragraph, therefore, the law framed by the Parliament provided for the complete ouster of the jurisdiction of the High Court, whereas the law framed by the state legislature prescribed for partial ouster of jurisdiction, that is the single judge's jurisdiction. Then in L. Chandra Kumar, the Supreme Court, considering the judgment in Keshavananda Bharati and the other judgments, came to the finding that power of judicial review by the Supreme Court and High Courts constitute basic structure. The Supreme Court in L. Chandra Kumar restored the power of judicial superintendence of High Court, but before division bench, the Honorable Supreme Court, being aware that in some High Courts, writ petitions are admitted and finally decided by Honorable single judges, yet directed exercise of judicial superintendence by division benches of High Court. The judgment of L. Chandra Kumar is a law declared by the Honorable Supreme Court under Article 141. When the Honorable High Court takes up matters under 226, 227, sitting in division benches, it is not an appeal under clause 15 of the latest patent. Rather, it is exercise of original jurisdiction of judicial review of judicial orders passed by tribunal. Judicial review can be of legislative action, administrative action, apart from judicial review of judicial decisions. Therefore, there can be no bar of the High Court sitting in division benches to judicially review actions of administrative authorities. On the issue of losing one forum,
But they are also, Mr. Dotto, as Mr. Lahiri pointed out, please come to L. Chandra Kumar, paragraph 55.
Para 85.
55.
Yes, yes. There are 3 judicial reviews.
Judicial review of
Yes.
legislative action, judicial review of judicial action, and judicial review of administrative action.
Yes.
Then what is striking is the last line.
Last sentence.
We are for the present concerned only with understanding of the first 2 aspects,
Yes, yes.
excluding judicial review
Of administrative
action.
Milord, the Supreme Court, in the facts of that case, was not considering administrative action, judicial review of administrative action.
Right.
Now, please consider one thing: whether judicial review of judicial review of administrative action, whether Milord several or separate parameters are there. Parameters are all same.
Yes, definition, so far definition subscribed to judicial concept of judicial review, there is no ambiguity. There are 3 facets as it emanates from paragraph 55. But so far L. Chandra Kumar is concerned, that is confined to first 2 facets, excluding the last facet, that is judicial review of executive action.
Right. Now, please consider one thing, Milord. Here in paragraph 55, the Supreme Court was trying to analyze how many types of judicial review are made by the judiciary. Legislative, administrative, judicial. Now, for administrative, subject to correction, Milord, again, there cannot be any separate parameters. The parameters are the same. If the single judge can judicially review judicial and administrative orders, legislative orders, it can also judicially review administrative orders. That is what your lordships are doing sitting in the single judge bench every day. All 3 types of matters are coming before the court in the single bench, division bench, wherever. So the last line in paragraph 55 is only indicating what are the issues which are under consideration in this judgment. For administrative action, Milord, Supreme Court doesn't say that the parameters are different. Or in practice also, your lordships are not differentiating between administrative action judicial review with the other judicial review. The same benches, Milord, in whichever determination, they are, Milord, judicially reviewing all 3 factors. Rather, there are so many other aspects.
Apart from these 3 aspects.
Executive action, for example. Here it does not take care of executive action. Your lordship are judicially reviewing the executive action. Yes. Now, my lord, therefore, my lord, this last sentence in paragraph 55, in my very humble submission, will not make any difference. Unless my learned friends can demonstrate before the court, no, the judicial review of administrative actions are completely different. Therefore, L. Chandra Kumar doesn't apply in case of administrative action. But that will be a self-defeating argument. Before the tribunal, we all go generally against administrative action. Suspension. It's not an executive action. Dismissal. Pay scale.
All are administrative actions.
All administrative actions. Then, my lord, in the second page, my lord.
Yes.
Please take the second paragraph. Judicial review can be of legal, etc. Then, my lord, next paragraph on the issue of losing one forum, that is right to carry intra-court appeal. Clause 15 of the latest patent confers such right. Right of appeal is a vested right. This vested right of appeal can be taken away only by a subsequent enactment if it so provides expressly or by necessary intendment. The Administrative Tribunals Act, having ousted the jurisdiction of the High Courts in its entirety, has also by necessary intendment taken away intra-court appeal rights as well. So whatever is available in the High Court is taken away. Single division, intra-court appeal, etc. Powers of High Court under the latest patent is recognized and saved by Article 225 read with Article 372 of the Constitution. These powers are akin to constitutional powers. Clause 15 appeal cannot be taken away unless specifically excluded. Clause 44 of latest patent declares that the provisions of the latest patent are subject to the legislative powers of the appropriate legislature. In other words, provisions of the latest patent can only be taken away by a legislation. Administrative Tribunals Act has scuttled the provisions of latest patent, including clause 15 thereof. The Honorable Supreme Court in L. Chandra Kumar could have restored the power of judicial review before the single judges of the High Court. Having not done so, if the High Courts entertain application in the single bench, it would amount to rewriting the judgment in L. Chandra Kumar. This can only be done by the Supreme Court. On the other hand, creating a right of appeal is a legislative action if such right of appeal is incidentally created by entertaining writ petitions by a single judge. It would incidentally amount to judicial legislation as well. Then, Milord, T. Rangarajan, Milord, I have tried to distinguish that in T. Rangarajan, Milord, by a stroke of pen, Milord, all the striking employees' job were taken up. The tribunal was functioning through a single member. Single judge, division bench, then it goes to the Supreme Court. Supreme Court says that this is an exceptional circumstances. We cannot expect all the persons to go before the tribunal. And in that background, the case has been decided. Again, Milord, that principle would also apply. These points were not raised. What I am raising, whatever may be the worth of it, these were not raised and not decided. Therefore, T. Rangarajan, it is a case of one of its kind, not deciding this issue. Therefore, Milord, I don't think that T. Rangarajan can, Milord, empower the single judges to, Milord, entertain these applications. But these are the points which I have jotted down for your Lordship's consideration. And I don't think I need to add anything, subject to what Mr. Bhattacharya said.
Thank you. This assistance I wanted, that's why I did it.
Right.
Because it struck my mind that
I can keep up to the expectation.
Yes, yes. No. That's why I have traveled.
No,
Deepest
my
of
pleasure,
respect,
Milord.
The fallacy of the argument on the advocacy, Milord, is inherent in its own argument.
No.
He says the judicial review before the division bench is available. Of what action? Administrative action. What L. Chandrakumar says? That administrative action first go as a first court to the tribunal, and any decision by the tribunal, that is the judicial decision, one step above. Administrative actions they have decided, and that decision of the tribunal would go to the division bench. Following the basic principle of first court, L. Chandrakumar repeatedly said that a tribunal should be the first court of judicial review. And it does not take away the inherent constitutional right of Article 226, 227. It says, well, I will take you, that remains. But constitutional power is exercised to filter out. The High Court may not be burdened to filter out. At the first instance, it will go to the tribunal. What we are facing, there is no tribunal. Then my constitutional right under Article 226 remains. And then I have to approach the court for first judicial decision of an administrative action. The first court is this court, And my lord, our writ is my lord, controlled not by latest patent anymore. We are governed by statutory rules. High Court rules are there, appellate side rules are there. I will just take your lordship, my lord, that the appellate side rule empowers the parties to prefer appeal. Here, my lord, only clause 15 was taken as an assistance. There is a mentioned note. But kindly come to the right of appeal under the writ procedure. This is my lord will state I do not
Writ rules.
Writ rule. These are, my lord, statutory rules framed by the High Court having constitutional force. Here the right of appeal is granted by
Which rule you are
I'm just taking the lordship, my lord, to the relevant rule for preferring appeal. Kindly come to the rule 48. Proceedings. Proceedings. কোন চ্যাপ্টার মধ্যে রিট কোন চ্যাপ্টারটা আছে এটা as in its whole ওটা রুলস 226 rules, sorry
226 rules.
Yes.
Just a minute.
Well, up to 46, because the many procedures have been laid down, original side, appellate side, what is to down, how I am not troubling my lord with that. The appeals from the orders of the got it?
Yes.
Appeals from orders in this jurisdiction shall be made in the original side if the original side is passed in the original side and in the appellate side. If the original order is passed in the appellate side by presenting a memorandum of appeal drawn up in accordance with the original side rules or the appellate side rules, in the case may be together with a certified constituency. Provided, however, leave may be granted by the appeal court to present the memorandum of appeal without the certified copy of the order if an application has been made by the appellant for a certified copy. All other rules of original side, appellate side will be made applicable. Therefore, here the appeal provides under this rule.
But that is a procedure.
Procedure, I say.
But the power or the right to appeal is derived from clause 15.
Yes, the cause
of procedure.
It's a procedure. Therefore, the procedure, Lord, recognizes my right to appeal before the division bench. Here also under the procedural aspect, that at the first instance, my lord, this is very important point, lordship, lord, that struck me, that the judicial review of the administrative order was not considered by Chandrakumar because Chandrakumar is considering that administrative order judicial review lies at the first court. What would be the order, a challenge from the tribunal? That should go to the, not to the Supreme Court, but to the High Court Division Bench. The High Court Division Bench is getting the benefit of a judicial discussion of an administrative action.
That you have stressed on the last occasion that there has to be a groundwork by way of forming a decision and that decision to be placed before the division bench for exercising judicial review.
And if we take that the first instance we have to come to the division bench, then we'll be betraying the Del Chandrakumar. I'm just placing those paragraphs. I think and advocate will also consider this aspect.
May I take your lordship's leave, my lord?
That is Mr. Bhattacharya. When this court has said it's a procedure, then Mr. Bhattacharya is shifted to L. Chandrakumar.
No, I say that the procedure laid down accepting that your appeal should be with the division bench.
Yes.
That's why I'm pointing out.
So many things are left to be learned from Mr. Bhattacharya.
Yes.
Now kindly come to the paragraph 81.
Of Chandrakumar?
Yes, Chandrakumar. Now I should start from paragraph 79. But you must have noted that earlier operation also have this.
Just a minute. 81.
Well, kindly come to 79.
89.
79.
79. Yes, 79.
We also hold that power vested in the High Courts to exercise judicial superintendence over the decisions of all courts and tribunals within their respective jurisdiction is also a part of the basic structure of the Constitution. This is because a situation where the High Courts are divested of all other judicial functions apart from the constitutional interpretation is equally to be avoided. There are all sorts of superintendence, judicial action, High Court, Constitutional Court is available. Then can you come? If the paragraph 81, if the power under Article 32 of the Constitution, which has been described as the heart and soul of the Constitution, can be additionally conferred upon any other court, there is no reason why the same situation cannot subsist in respect of the jurisdiction conferred upon the High Courts under Article 226 of the Constitution. So long as the jurisdiction of the High Courts under 226, 227 and that of this court under Article 32 is retained, there is no reason why power to test the validity of legislation against the provisions of the Constitution cannot be conferred upon the administrative tribunals created under the Act or upon tribunals created under Article 323 of the Constitution. It is to be remembered that apart from the authorization that flows from Article 323 and B, both Parliament and state legislature possesses legislative competence to effect changes in the original jurisdiction of the Supreme Court and the High Courts. These powers is available to Parliament under so and so. Then kindly come to me, Lord, and next important paragraph is paragraph 89. No, not 88, 90, sorry.
Paragraph
90.
Yes, Mr. Bhattacharya, you have in details.
I'm sure we have noted in detail. And there your lordship has been kind enough to notice that tribunal is a supplemental role, the court of first instance.
On the other hand, to hold that all such decisions will be subject to the jurisdiction of the High Court.
Now, my lord,
Last part of paragraph 90.
Now, my lord, to that, I think, my lord, the High Court, if we are allowed to approach the High Court because of a particular situation, not that, my lord, tribunal is functioning.
After constituting tribunal, if tribunal is non-functional.
Therefore, there is no constitution. Can you imagine a situation that some state did not
And the system which was prevalent, that will be revived.
That's the more fundamental thing. Other things I don't think I have to waste my lifetime time.
Yes, sure. In the writ petition, preliminary issue needs to be decided. That is, in absence, that is whether in absence of, that is when West Bengal Administrative Tribunal becomes non-functional, as vacancies in the tribunal are not filled up.
Last paragraph is specifically for us.
Single bench of High Court is to entertain a writ petition relating to service of a relating to state government service, or litigant is required to approach the division bench without approaching the single bench. Division bench of High Court without approaching the single bench. Stop. Issue on merit as involved in this writ petition to be decided later on, and this court finds it necessary to decide the preliminary, aforesaid preliminary point first. As the
writ petition is filed before this court pertaining to state government service. Stop. In terms of Section 28 of the Administrative Tribunal Act 1985, within bracket hereinafter referred to as said Act of 85, close bracket. Provided ouster of jurisdiction of the High Court in the matter of recruitment to any service or post or service matters concerning members of any service or persons appointed to any service or post. Stop. As per Section 28, post decision of tribunal, issue was required to be agitated before the Honorable Supreme Court. Stop. Section 14 and Section 15, while providing jurisdiction, powers, and authority of Central Administrative Tribunal and State Administrative Tribunals. Saved the jurisdiction of the Honorable Supreme Court, but no other courts, including high courts. Stop.
Next paragraph. Article 323A and Article 323A within bracket 2 within bracket D and Article 323 hyphen capital B within bracket 3 within bracket D excluded jurisdiction of all courts including high courts except jurisdiction of the Supreme Court under Article 136 with respect to the disputes and complaints referred to in clause 1 under the aforesaid two articles. দরকার নেই এটাকে না করে দাও আর্টিকেল 323 A 2D excluded jurisdiction of all courts including high courts except Supreme Court under Article 136 with respect to disputes and complaints referred to in clause 1. Stop. Therefore, on promulgation of Administrative Tribunal Act 1985, high courts didn't have jurisdiction to entertain applications/appeals against the decision of the tribunal. And the issue was taken into consideration by the Honorable Supreme Court. In L. Chandrakumar versus Union of India and others, reported in 1993, Volume 3, SCC 261. Stop. Seven-judge bench of the Supreme Court in paragraph 99 finally enunciated law, thereby declaring Clause 2D of Article 323A and Clause 3D of Article 323B comma to the extent they exclude the jurisdiction of high courts and high courts
and the Supreme Court under Articles 226/227 and 32 of the Constitution, are unconstitutional. Stop. Section 28 of the said Act of 1985 and exclusion of jurisdiction clauses in all other legislations enacted under the aegis of Articles 323A and 323B to the same extent was declared unconstitutional. Stop. It was also observed in paragraph 99 that jurisdiction conferred upon the High Courts under Article 226/227 and upon the Supreme Court under Article 32 of the Constitution is a part of the inviolable basic structure of our Constitution. Stop. While this jurisdiction cannot be outstayed, other courts and tribunals may perform a supplemental role in discharging powers conferred by Articles 226/227 and 32 of the Constitution. Stop. In paragraph 91 of L. Chandrakumar Supra, it was held that all decisions of tribunals, whether created pursuant to Article 323A or 323B of the Constitution, would be subject to the High Court's writ jurisdiction under Article 226/227 of the Constitution, before a division bench of the High Court, within whose territorial jurisdiction the particular tribunal falls. Next paragraph. On the anvil of the ratio of L. Chandrakumar Supra, court is required to examine whether in the backdrop of facts where tribunal becomes non-functional, where West Bengal Administrative Tribunal becomes non-functional, writ petition at the first instance is required to be entertained by the single bench of High Court, or litigant should approach the honorable or approach the division bench straightway. Stop. Next paragraph. From the submissions made on behalf of the parties, it is indisputable that West Bengal Administrative Tribunal যেটা বলছি না, herein after referred to as tribunal করে দাও, না সব জায়গায় শুধু repetition হয়. It is indisputable that tribunal is not functioning as chairman and other members, as vacancies of chairman and other members are not filled up. Stop. Pitted against such order, petitioner has approached this court though the issue involved in the approach this court with the present writ petition. Though the issue involved in this writ petition was required to be examined at the first instance by the tribunal. Stop. Next paragraph, Mr. Vikas Ranjan Bhattacharya, learned senior advocate, representing the petitioner. Submits that as tribunal is non-functional, petitioner may be permitted to move this court, may be permitted to move this court, or may be permitted to move this writ petition. And if move this writ petition, stop. It is further submitted that if petitioner is directed to move the division bench, skipping over learned single judge, or skipping over this court, in that event, petitioner will lose a forum. Stop. In support of such contention, reliance is placed on paragraph reliance is placed on L. Chandrakumar Supra, comma, (2003) Volume 6, SCC 581, T.K. within bracket T.K. Rangarajan versus Government of Tamil Nadu and others. And 2020 Volume 6, SCC 1, Roger Matthew versus South Indian Bank Limited, within bracket. Stop. Next paragraph, placing reliance on the observations made by the 7-judge bench in L. Chandrakumar Supra in paragraphs 90, 91, 93, 94 and 99, it is contended on behalf of the petitioner that in order to attract the requirement of approaching the Honorable Division Bench under Article 226/227 of the Constitution, a decision of the tribunal is required, which forms a ground for exercising power of judicial review by the High Court. Stop. In absence of such decision, litigant is required to approach Honorable Single Bench, or approach to litigants are required to approach Single Bench of High Court. Stop. In addition thereto, it is further contended that tribunal is not tribunal is supplemental tribunal is playing supplemental role in discharging powers conferred by Article 226/227 and 32 of the Constitution. In other words, tribunal acts as court of first instance in respect of areas of law for which it has been constituted. Stop. Next paragraph. Mr. Kishore Datta, learned Advocate General, appears on behalf of state respondents. And has submitted Administrative Tribunal Act 1985 is relatable to Article 323A. Whereas the West Bengal Land Reforms Act 1955, whereas the West Bengal Land Reforms and Tenancy Tribunal Act, 1997 is relatable to Article 323B of the Constitution. As per Section 28 of Said Act of 1985, there is total ouster of jurisdiction. There was total ouster of jurisdiction of the High Courts, the position was altered by virtue of the judgment of the Honorable Supreme Court in L. Chandrakumar Supra. Thereby saving power, authority of the High Court to exercise power of judicial review under Article 226/227 of the Constitution. Semicolon. Section 8 of the West Bengal Land Reforms and Tenancy Tribunal Act saved the jurisdiction of High Court, saved the jurisdiction of Division Bench of High Court under Article 226 and 227 of the Constitution. Under Article 227/220, under Article 226/227 of the Constitution. Stop. Accordingly, it was pointed out that there is marked differences with regard to the jurisdiction of High Courts in terms of Section 28 of the Said Act of 1985, qua Section 8 of the West Bengal Land Reforms and Tenancy Tribunal Act 1997. Stop. Next paragraph. It is also it was also contended on behalf of the state respondents. It is contended in view of law laid down in the backdrop of law laid down in L. Chandrakumar Supra, restoring power of judicial review, judicial superintendence of high courts, but before the division benches. It was submitted that the Honorable Supreme Court, in spite of being aware of the position that in some high courts writ petitions are admitted and finally heard by single judges, by the honorable single judges, though directed exercise of judicial superintendence by the division benches of high courts. Another limb of submission advanced on by the learned advocate general is right to prefer appeal against the order of the single bench is derived from clause 15 of latest patent subject to the conditions as delineated under clause 44. Stop. relating to the point agitated on behalf of the petitioner that in the event petitioner is directed to approach the division bench with the writ petition, said petitioner would lose a forum. It was argued right to carry intra-court appeal, or it was argued that right of appeal is a vested right. Such right can be taken away only by a subsequent enactment, comma, if it so provides expressly or by necessary intendment. Stop. Said Act of 1985 having ousted the jurisdiction of the High Courts in its entirety, comma, has also by necessary intendment taken away intra-court appeal right as well. Therefore, it is contended that in the event, আচ্ছা এখানে এটা করার দরকার নেই, কেটে দাও। Next paragraph, submission is also made to distinguish ratio of the judgment of Supreme Court the submission has also been made to distinguish ratio of T.K. Rangarajan Supra. Stop. আচ্ছা ওখানে জাস্টিস মিস্টার ভট্টাচার্যের যে সাবমিশনটা আছে একটা লাইন পরে অ্যাড করে দাও, পরে একটা প্যারাগ্রাফ অ্যাড করে দাও। রিলায়েন্স ইজ অলসো প্লেসড on behalf of the petitioner upon order dated 19 December 2025 passed by the division bench on an inter-court appeal being MAT 2211 of 2025 within bracket Ornab Odhikari and others versus State of West Bengal and others, and another order dated 19 December 2025 and another order dated 12 June 2025 passed by the Honorable Division Bench passed by Honorable Division Bench on an intra-court appeal being WPST 4 of 2025 within bracket Runu Ghosh versus the State of West Bengal and others, close bracket. তারপরে এখানে চলে এসো।
Gunu Ghosh was not an interpol. Gunu Ghosh was not an interpol. They had filed in SAT, went to division bench directly.
Right. একবার বলো। Right. WPST number is there. Right.
WPST.
Yes. It was sent to the single bench. কি বলছিলাম? Now, on a writ petition being WPST 4 of 2025, within bracket Runu Ghosh versus the state of West Bengal and others. Close bracket. Next paragraph. For better understanding of the issue involved in this writ petition, this court finds it apt to quote paragraph 55, paragraphs 55, 90, 91, 92, 93, and 99 of L. Chandrakumar Supra below. Next paragraph. In L. Chandrakumar Supra, Honorable Supreme Court saved the power of judicial review of high courts under Article 226/227 of the Constitution. Stop. Such power of judicial review was discussed in paragraph 55 in consideration of J. full stop Abraham's definition of judicial review in American context. And it was observed that, subject to few modifications, such definition is equally applicable to the concept as it is understood in Indian context, as it is understood in Indian constitutional law. Stop. Three facets of judicial review was taken into consideration. Those are judicial review of legislative action, judicial review of judicial decisions, and judicial review of administrative action. However, Honorable Supreme Court in L. Chandrakumar Supra confined their its discussion and application thereof. In connection with judicial review of judicial decisions and judicial review of administrative action. Judicial review of judicial decisions and judicial review of administrative action. No. Judicial review of legislative action and judicial review of judicial action. Judicial decision. Judicial review of legislative action and judicial review of judicial decision, excluding judicial review of administrative action. Stop. Judicial review of judicial decision and judicial review of judicial review of legislative action and judicial review of judicial decisions were elaborated in paragraph 90 and paragraph 90 and paragraph 91 respectively. So ultimately in paragraphs 90, 93 and 99, paragraphs 90, 93 and 99. It was held that role of tribunal is supplementary. Stop. Now, role of tribunal is supplementary and all decisions of tribunals would be subject to scrutiny before the division bench of the respective high courts. It was also observed in paragraph 93. Now, it was also observed therein that tribunals would, however, continue to act as the only courts of first instance in respect of areas of law for which they have been constituted. Furthermore, Honorable Supreme Court in L. Chandra Kumar Supra emphasized on necessity of a decision which can be subject matter of judicial review to be exercised by the division bench while entertaining or while deciding writ petitions under Article 226/227. Next paragraph. Here, as here in the present case, or here take it down. In the present case, since tribunal is non-functional, there is no decision of the tribunal which can be examined by the by the division bench in exercise of its power of judicial review. Stop. Without decision of the tribunal, if straightway petitioner approaches the approaches division bench for exercise of power of judicial review, in that event said petitioner would lose a forum. Stop. In this regard, reliance is placed on paragraph 25 of Rangarajan Supra, wherein Honorable Supreme Court considered a special situation where large number of employees were terminated at one hand, and on the other hand, there was one member in the tribunal comma, it was found necessary to approach the High Court to ensure justice should not be denied to the affected persons. Stop. In Roger Matthew Supra, Dr. D.Y. Chandrachud J., while supplementing and partly dissenting views of other honorable members of the bench, observed in paragraph 392 that in whichever state/union territory the bench of a particular tribunal is not established or functioning, comma, the litigants of that state will have a right to invoke extraordinary writ jurisdiction of the jurisdictional high court under Article 226 of the Constitution for redressal of their grievances. Stop. Next paragraph. Notwithstanding right to prefer appeal emanates from clause 15 of latest patent, as urged by the learned Advocate General, as urged by the learned Advocate General. As the said issue as found is yet to be taken into consideration. By the Honorable Division Bench. Court finds in the present circumstances access to justice ought not to be denied when tribunal becomes non-functional. Issue relating to preferring appeal under clause 15 of latest patent, read with clause 44, may be taken into consideration in an appropriate situation by the bench of highest strength, But this court needs to take into consideration now by the court of higher strength, and accordingly is kept open. Semicolon. But this court is required, this court is required to take into consideration. Or, but this court is bound by the decision of the honorable division bench. Passed in Arnab Adhikari Supra and Runu Ghosh Supra. Stop. In Arnab Adhikari Supra, video order dated 15 December. No. Video order dated 19 December 2025. Honorable Division Bench directed the registry to place the writ petition before the appropriate regular bench, within bracket, this court, close bracket. For consideration based on the observations made in paragraph 6 of the said order. Stop. In Runu Ghosh Supra, another honorable division bench, video order dated 12 June 2025, taking note of ratio of Roger Matthew Supra. Observed that petitioner in that writ petition was required to approach the single bench having appropriate jurisdiction. Stop. It was also held therein application made seeking judicial review before the division bench cannot be entertained, since there was no order of the tribunal which can be subject matter of judicial review. Next paragraph. In view of aforesaid discussions, as tribunal is not functioning at present. As tribunal is not functioning, writ petition is found to be maintainable before this court. Stop. So accordingly, preliminary issue is decided. Stop. List the writ petition under the same heading for adjudication of the same on merit on
There is some urgency, my lord, because they are proceeding with the recruitment.
Give me some time to
Yes.
correct it and put signature on it.
Yes.
Considering the urgency, I dictated this order
And
in open
next-
court.
Tomorrow onwards, we will be coming. Today, I didn't mention matters.
Till I sign this order, I will not entertain any matter. 21st January 2026. Diplomas.
Let's say I am for the state, let's say with the advocate general, learned advocate general. Let's
Your application is there. আচ্ছা দেখো একটা কেন আছে টুডে ক্যান ওয়ান দেখো but it is not appearing in the list. Really, on the next day, this can is to be tagged and it is to be disposed of. But that is not on list. I cannot dispose it. এক্ষুনি তাহলে আজ থাক পরের দিন yes
say I meet learned
corrections and put signature.
let's say I am meet learned advocate general in this
Yes,
matter.
yes, yes.
Okay.
Other questions will also come now.
জাজমেন্টই করে দাও ইস্যুটা তো ডিসাইডেড হয়ে গেল এটা জাজমেন্টে করে ট্যাক্স করে সব কিছু আমি পাঠিয়ে দাও এইটার সময় পাঠাবো তুমি আবার কনস্টিটিউশনটা নেবে হ্যাঁ এটা পকেট কনস্টিটিউশন না আমার আমায় পাঠিয়ে দেবে ভরে করবে যদি আজকে নাও হয় কালকে মনে
ওইটা কোড করুন
rightly pointed out it was WPST not appeal.
Can I dictate the appellate side rules or your law?
Yes, appellate side rules. Yes, I have not considered it. It's a procedure. Substantive power of appeal emanates from clause 15.
Develop.